Hello and welcome to the Patent Pending Made Simple podcast. I'm your host, Samar Shah, and with me is Jamie Brophy. Jamie, how are you?
Hey, Summer. I am good. How are you doing?
I am doing all right. I am enjoying the warmer weather that we've been having, so things are good.
Yeah, yay spring, and summer is quickly approaching.
Yeah, I can't believe we're so close to summer at this point. My kids are counting down the days. I think they said there's 6 more days of school left, something like that, so they are
Wow.
excited.
Yeah, yep, mine too. We're in the same boat.
All right. Well, today's topic is what is the purpose of a patent or a patent application, maybe. So maybe we'll talk about that. Sometimes clients ask us this, right? When they call us or we're working through an application, they're like, what is the point of this? Do you get this question, Jamie?
Yeah, sometimes. And, I think a lot of the times it depends on what the client's goals are or what their business plan is. Speaking, the purpose of a patent is your patent gives you the right to exclude others from, making or using your invention. And maybe you can talk about that a little bit more, Summer, but that is the legal purpose of a patent.
That's right. Yeah, that is exactly the legal purpose of a patent, is the right to exclude somebody from making, using, selling, importing that invention in the United States, right? We're talking about a US patent here. You could theoretically get patents in other countries to give you similar rights, but I think it's 35 US 257. It allows you to prevent other people from making, using, selling, or importing the invention in the United States.
Right. And I think an important distinction here is it gives you the right to exclude others, but it doesn't necessarily even give you the right to practice your invention. Right, Summer? You want to talk a little bit more about that?
Yeah, this can get a little confusing because clients or inventors think that, oh, I got a patent on this thing. That means I'm the only person who can practice this invention. And that is technically correct, but it's not an affirmative right. So the right that the patent grants you is a negative right, right? So it doesn't give you an affirmative right to do anything at all other than to stop people, right? So it's a negative right in the sense that you can stop other people from doing certain things, which would be considered infringing activity. And it maybe gives you the right to sue those people or to have a conversation with those people to engage in some kind of a licensing arrangement or a deal, but it doesn't give you the right to actually go out and practice your invention or sell a product in any way. That's just not what the legal right is.
Right. So, yeah, I'll give a very basic example here. So, say I invented a cup and it's got a bottom and it's got sidewall and it's made of a material that is rigid and waterproof. I can put a liquid in it. So, I invented this cup. And then you come along and you invent a cup with a handle and you get a patent on your cup with a handle. Well, you can't make the cup because I have a patent on the cup, but you have the right to exclude others from making, a cup with a handle, even if you can't necessarily make it, because if you were to make it, you would be infringing on my patent to the cup without a handle, if that makes sense.
Right. Yeah. No, I think that makes total sense. Just because you got a patent on something doesn't mean that you are not maybe infringing on somebody else's patent. So this question does come up quite a bit, right? A lot of people are under the assumption that they got a patent. That means they're free and clear from getting sued by somebody else. But that's not what the patent is. I mean, you could simultaneously have a patent and still infringe somebody else's patent, like you said, Jamie. The right vehicle for figuring out whether you might be infringing somebody else's patent is called an freedom to operate analysis or a non-infringement opinion of counsel. Those are the types of things that will give you more information about whether you're infringing somebody else's patent, but your own patent doesn't necessarily give you that right or even the sufficient information to make that determination. Sometimes in litigation context, sometimes we're able to use our clients' patents as a defense, right? Or not as a defense, but as a way to show that, like, hey, we've done innovative activity here and that we are truly different from what the plaintiff is claiming in a patent lawsuit. It's somebody else's patent. But oftentimes, evidence of your own patent is excluded as being prejudicial and not probative to the issue at hand in a litigation. So even if you have your own patent and you get sued by somebody else, you won't be able to use your patent as a defense. And more times, or more often than not, you won't even be able to present that evidence to a jury because it's not probative and prejudicial to the actual issue at hand.
Right. Yeah. So, yeah, it does get a little tricky. And we did do a previous episode on, patentability versus infringement. But yeah, I think this is all just to say your patent gives you the right to exclude others. And then, like I was saying at the beginning of the conversation, Summer, it kind of depends on what the client's goals are. I feel like we definitely have some clients that they just want to be able to say, I have this product and it's a patented product. In that case, it doesn't probably necessarily matter how broad or narrow the claims are. They just want to be able to say that they have a patented product. Have you found that to be the case at all, Summer?
Yeah, I think that's right. So Like if you start with the premise that a patent gives you the right to sue people, and if our clients are like, well, I don't want to sue anyone, so what good is a patent at that point, right? Like, does it have any other purpose to it? We strongly believe, Jamie, that there is a lot of value in that patent, right? It helps you do a lot of different things, but a lot of those things will depend on what your goals are, right? So I almost think of a patent as a vehicle or as an asset that helps you accomplish certain things. And those certain things may depend on what your business model is, what your go-to-market strategy is with your product, how you plan to monetize your invention, and so on and so forth. And for some, it's a vanity metric as well, right? Like they always wanted to be a patent holder or an inventor, and that means something to them. And meaning is powerful, as we know. So there's value there. But from my perspective, in terms of clients we work with, we're always trying to figure out what are your business goals and how can we turn this patent into an asset that helps you accomplish those business goals. So Jamie, do you want to talk about that a little bit in terms of what are the kind of the business goals that we commonly see from inventors or clients that we work with? And then we'll talk about how the patent may help them accomplish those goals.
Yeah, I think the two main ones that I can think of are sometimes clients come to us and they already know of a competitor on the market, or they already know of somebody that is trying to copy their product. So in that case, their business goal with the patent would be to stop that person from copying their invention. And then I think another business goal somebody might have is to get a patent to be able to license it to others so that they can get paid by people that want to, obtain the rights to make their invention, to make or use their invention. So like those are the two main ones that I can think of. Do you have anything else to add to that, Samar?
Yeah, I think those are good. I work with a lot of software and startup clients as well. And I know this is maybe not the right audience for it, but I do want, our listeners to be familiar with what these are. A lot of other business goals are, for my startup clients in particular, is to improve the value of the company, right? Because a lot of times they're out raising outside capital, venture capital. They're looking for investors, and patents help you lock those investors down, right? So help you attract investors. Or for some investors, like they have a rule that they don't invest in companies that don't have protectable IP or haven't filed patents. So they wouldn't even look at a startup without patents, right? So patents help you do that. They help raise the valuation premium that you're able to get a lot of times when you're raising money from investors. For a lot of my startup clients, like their biggest kind of revenue monetization opportunity comes when the company gets acquired by a bigger company. And a lot of bigger companies will give you a pretty nice premium for having patents as opposed to not having patents. And this is probably true for independent inventors too, right? Like I can imagine if you've been making and selling a product, you could be making a decent amount of margin and profit on it. But if a bigger company comes in to acquire that product, the rights to that product, they won't give you as much of a valuation premium or multiple if you don't have a patent. They'll give you a lot more if you do have a patent. Because as we talked about at the beginning of the show, the right that you have to sue people, you may not exercise that right as an independent inventor or even as a startup. It's just very expensive and distracting to the main business goals. But a bigger company does often have budgets for enforcing their patent rights. So they will value that and they will enforce that right in the marketplace through the legal system. So they put a huge amount of valuation premium on that. And often they are looking at it from the perspective of excluding other big companies. So it's worth a lot to them, even though it may not be worth as much to you from a litigation enforcement standpoint. So that's one. The valuation, I think, is a really important, really big part of the patent process for a lot of my clients. The other is that a lot of my clients enter into partnership relationships with other companies, whether it's a joint venture agreement or a partnership of some sort to bring a product to market. Like I have a lot of clients who are at the intersection of hardware and software, for example. One company is contributing the hardware, another company is contributing the software, and they're working together. It can get really messy. IP rights can get really messy in those situations, right? Like who owns the rights to the joint product or some things that bleed from one place to the other. Patents are really nice in those situations because they help you clearly define what's yours and what's theirs and what's maybe jointly owned together and how you can move forward with that relationship. And if things go badly in that relationship, who owns what, right? Like what can you practice and not practice without running into issues? Patents are really nice for those things as well. So joint venture partnership discussions, I think, are nice. And then the third thing I would say is that often my clients are also getting a license from other companies to to use in their products or software. And having a cross-licensing deal with a patent can sometimes help reduce the cost of that overall license over time. So we've had clients where they were looking at a license for $100,000 plus, but they were able to negotiate that down to like less than $10,000 because they cross-licensed their patents to each other. So like that was a $90,000 win for the client. I can tell you that they didn't spend $90,000 on their patent application. So it was a pretty nice return, but patents can be valuable from that perspective as well. And then the last thing is our clients will sometimes go out and raise debt capital from banks. Banks like to see collateral when they give you money, and you can use patents often as collateral to a loan, which is really nice because a lot of my clients, especially my software startup clients, they don't have any assets, so to like hard assets to speak of. Like they just have computers, but most of the assets of the company, so to speak, are intellectual property. But to turn that intellectual property into something tangible like a patent can help you collateralize a loan, which is kind of nice.
Yeah, absolutely. I think those are all good points. And I think a lot of what you just said is applicable to independent inventors, not just startups. Having that patent pending status might help you be able to attract investors and get people to work with you. So I think a lot of that is applicable. So yeah, I think there's the legal point of a patent. And then there's, as a patentee, you need to think about what your goals are with the patent. And that will help your patent practitioner point them in the right direction for, how to prosecute your patent application and what aspects of it might be, super important to you. So I think it's all good to think about. Yeah, I think a lot of people go into the patent application process thinking, okay, once I have a patent, I can make this product. And that's not the best way to think about it. That's not necessarily true. So I think this is all good stuff to think about. Do you have anything else to add, Summer?
No, I think that's great. Maybe I do. I'm thinking back to our interview that we had with Stephen Key, where he said the patent is a great marketing document, which we should mention here, right? Because one of the things that he said that I liked is that people stop questioning you, right? Because you are an inventor, you are an idea person. People doubt that all the time, right? Rightly or wrongly. They're just like, yeah, like that's a great idea, but I don't think you can protect that. Like I watched the show Shark Tank and they say that all the time. It's like, why wouldn't somebody just step on you like a cockroach that you are or something like that?
Yeah.
And patents give you that legitimacy, right? Like, and that marketing, like we don't love spending our time on this, but this is the reality of the marketplace is that people stop questioning you, right? If you're in a boardroom trying to hammer out a licensing deal or if you're in a tough negotiation, you can always wave that patent around because it is powerful. It does give you rights, maybe hard to enforce those rights, but it has value. And more than anything else, it has marketing value for our independent inventor clients and startup clients. So I think there's value in that. And then there is some kind of defensive value to it too, where, we see this on the other side where our clients are like, yeah, I'm trying to make this product, but there's this other product out there and it says patent pending or it says patented. Am I okay to proceed? So like it does make people scared on some level to compete with you, or at least makes them want to dig into it some more. Like eventually, if your product's big enough and if there is enough money at stake, people will get creative about circumventing your patent. But just the fact that you have a patent or your patent pending will potentially deter maybe 80% of your competitors who are just not that serious, right? But might become serious over time. So there is a marketing value to the patent as well, which we don't talk about because it's so intangible in my opinion. I like to talk about tangible things like real hard value stuff. And I think you do too, Jamie, but there is that aspect of patents that I think is kind of nice.
That's a great point. I can think of a couple clients off the top of my head where, when they initially entered the market, there were people saying they're not going to be able to get a patent on this, or, this is not going to be patentable. And then behold, they did get a patent on it. So it did give them some legitimacy and hopefully scared away some of those copycats. So yeah, I think that is a great point. That is another, super important purpose of a patent.
Yeah, agreed. Yeah, I think this is good. I'm glad we talked about this because it is something that I don't think people talk about enough. Everybody talks about, suing people, but I always tell our independent inventor clients that if you're suing people, you either made, $20 million plus, or we've kind of led you in the wrong direction. So I think there are other values there as well.
Yeah, definitely. Yeah, I think this was a lot of great information. Yeah, I don't have anything else to add. Unless you have anything else to add, Summer, I think we can wrap it up.
Yeah, I think so. And this time I don't have anything to add. So we'll wrap it up here for a change. But no, this is great. I'm glad we talked about it. I hope it was helpful to everyone as well.
Yes, definitely. Okay, I will talk to you next time.
Awesome. Thanks, Jamie.
Thanks.
Thank you for joining us on the Patent Pending Made Simple podcast. I hope you enjoyed our show. If you'd like to receive updates, view the show notes, or access a direct link to any resource, go to the episodes page on patentpendingmadesimple.com. To help others find our podcast, please like, share, and subscribe. Thanks again for tuning in. I look forward to having you with us next time on Patent Pending Made Simple. This podcast has been hosted by Outlier Patent Attorneys and is not intended to, nor does it create, the attorney-client privilege between our host, guest, or any listener for any reason. The content of this podcast should not be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.